All right, 11 o'clock. Welcome, everyone. We got a small group here, and maybe a few more will be joining us. Um, Jeremiah, thanks for joining. I know you and I haven't spoken for a long time, so I appreciate you being here. And Corey, thanks for jumping on. And Hunter, we've got you here too. This is fantastic. So we're going to be doing a short webinar this afternoon on restrictive covenants. I'm going to try to angle this so that you guys don't see the cars. That can be a little distracting. There we go. And I wanted to maybe just give a high-level overview of different kinds of restrictive covenants that we run into in our employment law practice. And then we'll dive into some of the problems that we see. It's interesting, the problems that we run into, we tend to run into pretty frequently. And so we asked around the office, and we had several people, several attorneys on our team who have run into some of these issues just as recently as this week and last week. So that'll be interesting to see what we're seeing out in the field and make sure we're doing things correctly and make sure that the business owners that you guys are or that you're working with are doing things right and staying out of trouble. So I put together a short list of the primary kinds of of restrictive covenants that we tend to see. And of course, non-competes is at the top of the list. Those are the ones that come through the most often, and they tend to be the ones that cause the most trouble for our clients. So we'll talk about those and the rules that are in place for non-competes. We also see a lot of non-solicitation agreements, which are very different than non-competes. We see non-disclosures, NDAs, um, uh, covenants regarding the destruction or the return of company property, both physical and intellectual property. Non-disparagements tend to come up pretty often. We have post-employment restrictive covenants regarding like invention assignment. So things that employees develop and come up with while they're working for the company belong to the company, and sort of their obligations to make sure they pass all that information back to their employer before they go. Those are the primary ones that we tend to see here in the US. And so we're going to focus in now on the differences, kind of high level, between non-competes and non-solicits, because those do tend to get business owners mixed up from time to time. And the way that we like to describe it is this, that a non-compete is telling somebody where they can or cannot work, or what restrictions are they going to be under for working opportunities after they leave the company. That's a non-compete. And a non-solicit is basically a promise where the employee says, I promise I'm not going to steal your customers or steal your employees after I leave. So soliciting, reaching out to vendors, key business partners, former or current employees, and trying to pull them away. That's a soliciting type of activity. It's really very different than a non-compete. And the rules for non-solicits and non-competes are different as well. So the primary rules that tend to get business owners in trouble when it comes to non-competes came into play in 2016. And that's when the Utah State Legislature passed a new law called the Post-Employment Restrictive Covenants Restrictions Act. And what they did is they said, starting in May of 2016, we want all non-competes that are being signed now or in the future to be limited to just 12 months or less. And the language of the new statute actually says that if the post-employment or the non-compete is more than 12 months, then it is not just unenforceable, but they actually use the term void. And we've had a lot of discussions in our firm about what does it mean when the statute says something is non-enforceable versus it's void. And our conclusion, even though I don't know that there's any judges since 2016 that have really ruled on this issue, surprisingly, our opinion and our advice that we've given to clients is that if the non-compete is signed after May 16th of 2016 or May 10th of 2016, yes, that it is totally not enforceable, it is totally void, and that if the employer tries to enforce it against the worker, then the employer is very likely to be on the hook for that employee's attorney's fees, court costs, and other kinds of damages. And so what we do is when we get a non-compete and we're asked to evaluate whether it's effective, whether it needs to be rewritten, et cetera, one of the main things we look at is what is the time frame. And so just recently, I think in the last week or two, we have a couple of non-competes that have come in that were really interesting. And so what I've done is I printed them up and I want to read you a couple of provisions from them. So this is a non-compete agreement, and the first opening sentence of the non-compete says this. This agreement begins on the date of employee's employment with the company, which is normal, it starts on the date that they sign it or when they start working, and shall last for 5 years after that employment ceases to work for the company. So there's a typo in there. It meant to say for 5 years after that employee ceases working for the company. So I think that language is fairly clear that you've got a non-compete here, and for 5 years after you stop working here, you're not allowed to work at these competitors, which are then described below. Interestingly enough, is this non-compete then has another section that comes next, and it says something that's very contradictory. This agreement shall take effect on the day on which employee ceases to work for the company. So there's a different effective date. Before it was effective when they started working, and now it's effective on the date when they leave. And then it says the non-disclosure shall end 5 years from that date. Okay, non-disclosures, they can be 5 years. Non-competes shall end 2 years from the date in which the employee ceases working for the company. So in section 2, it says it's a 5-year non-compete. And then right after that, it says in the next section that it's a 2-year non-compete. And unfortunately, both of those provisions are void and unenforceable because they violate the Utah Post-Employment Restrictions Act, which says, as we talked about, that non-competes are limited to a maximum of 1 year or 12 months. They certainly can be less, they just can't be longer. And then we had another one, and this is a really detailed, really lengthy agreement that the employees were asked to sign. And it's something close to probably 10 or 11 pages. My guess is it was prepared by an attorney with a lot of the key language that's in here, but probably not prepared by an employment attorney, because when you go to the non-solicitation / non-hire provision, it says that the non-compete is going to last for a period of 2 years after the date on which the restricted party's employment has been terminated. So both of these non-competes, clear violations of the 1 year, 12-month maximum that the Utah State Legislature put on non-competes in the state of Utah. Now, of course, lawyers and the state legislators, when they're writing up laws, there always seem to be exceptions, right? And there are exceptions to this 12-month rule. The primary exceptions that we run into in our practice are, number one, if somebody is being let go and they're being offered a severance payment or a severance agreement. And so in the severance agreement, you'll see a lot of post-employment restrictive covenants. There may be a non-disparagement that says you won't say bad stuff about us. There may be a return of company property, non-solicit, non-compete. All those things are pretty common to see in a severance agreement. And one of the exceptions that the state legislature wrote into this new law is that when a business is letting somebody go and they're paying some kind of a payout, like a severance payment, it's essentially a bargain for exchange. The employee is given certain rights to the employer that they don't have a right to, and the employer is given certain rights back to the employee that they don't have a right to. And so when that kind of exchange is happening, the state legislature said that's one of the exceptions where the non-compete can be more than 1 year. The other place that we tend to see that the exceptions come up is when a business owner is selling a business. So business owner's got somebody who's interested in buying, they want to sell the business to this person, and it wouldn't make sense to, sell a business for $1 million and then turn around and restart that exact same business the next day. And so when a business is being sold and there's an exchange of value, that's another time where the state legislature said, it's okay for a non-compete to be more than 1 year. It could be a 2-year, 3 years, as long as it's reasonable and it's written into the terms of the sale documents, that the non-competes, that's an exception where they can be more than the 1 year. Okay, so those are the primary rules or that we find with non-competes that are getting violated from time to time. I want to be really clear, though, if we're not talking about non-competes and we're talking about non-solicitations, that 12-month rule doesn't apply. That is just for the non-competes, okay? So if you have a non-solicitation agreement and you want to tell your employee that when you leave, I don't want you to steal, the best employees. I don't want you to steal some of our vendors or our key partners and relationships. Want you to leave all that safe so we can keep working with them. Those kinds of agreements, it's okay for it to be more than 12 months. Now, another issue that tends to come up with non-compete agreements is that they are written in a way that it's very clear that they just want to stop this worker from being able to get a new job. You can't do anything in the business of marketing anywhere in the whole US or anywhere in the whole world, that kind of thing. And one of the key factors that a court is going to be looking at when they're evaluating a non-compete that's being challenged in court is they're going to look to see if the language of the non-compete has been what we call narrowly tailored. And essentially what that is they want the language to focus on protecting the company or the business's legitimate, like their goodwill with their customers or their confidential proprietary information. Maybe if they've made big investments in training a certain employee on certain unique skills and they're trying to protect that investment. Like the non-compete needs to be written in a way that is not just telling this individual employee, you can't work anywhere, but it's narrowly tailored. It's written in a way that the person can go get a job, but we don't want them to take advantage of all this investment that we've just barely made in them to unfairly compete against the business. And so it's tough to give maybe specific examples about that, but that's why it's good to have a non-compete if it's being challenged or it's being rewritten. We want to make sure it's done correctly. It's a good idea to have that reviewed by employment counsel so they can advise you on, have we written this in a way that a judge would see it as being narrowly tailored? As far as time, like the 12-month limitation, as far as geographic scope, are we limiting it to the area where our clients and our customers mostly come from? Or are we making it so broad that this employee really can't go get a job anywhere? And it's more of a burden on the employee rather than a narrowly tailored protection for the business. So one example I will give you along those lines is a smaller type of business where we see non-competes frequently would be in the dental services area. And so if you just imagine an orthodontist, if an orthodontist has a non-compete for all of their staff and they say, you know what, it doesn't matter if you are the office manager who handles everything from marketing and finance, or if you're just a person who is, like an assistant and you're there just passing the tools to the orthodontist. But we're just going to require all of our employees to sign this real big burdensome non-compete. And the non-compete says you can't work for any other orthodontist in the state of Utah. That would probably be an overly burdensome, the exact opposite of a narrowly tailored non-compete. And the reason I say that is in industries like dental services, there are lots of people that offer those services. And so it's very common for an orthodontist or a dentist or an oral surgeon, et cetera, to get most of their patients or most of their customers from a rather narrow geographic area. So when I went to my orthodontist, I can tell you that most of his patients and clients came from probably like a 5-mile radius. You didn't have people traveling from Bountiful down to Utah Valley to see my orthodontist. He's great, but there's probably great orthodontists up in Bountiful that are serving people up in that area. So you have to take into consideration where most of your clients and customers are coming from, and then make sure that your non-compete is being written in a way to protect your business. It's narrowly tailored, like looking at where do our clients and customers come from. And we're going to write it in a way so we can protect what we've been building up all these years, but not put an unreasonable, undue burden on the employee who's leaving so that they basically have to move out of state or move out of the country to continue doing the type of work that they're good at doing. Okay, so those are the primary issues that come up with non-competes. The 12-month thing, if you have a non-compete, go back and check it, make sure it's 12 months or less. If it was a non-compete signed before May 10th of 2016, then there are certain instances where maybe it can be more than 1 year. But given that we're almost 10 years out from that now, most non-competes have been signed after that date. Make sure that they're 12 months or less. Make sure that the geographic limitation that you have makes sense for your business and that you would be able to stand in front of a judge and say, here's why I wrote it this way. It's protecting our business interests. It's not being unduly burdensome on the employee. And as long as you can meet and pass those tests, your non-competes are probably going to be in much better place than a lot of the ones that we see here at our practice. All right. Let's see, any other things that another issue that I just learned about recently because it just became effective at the very end of May, is there is a new statute in the state of Utah for healthcare providers. And so this is House Bill 517. And basically what it said is people like therapists and counselors, et cetera, if they have a non-compete with their employer and their employer has more than a 2-month waiting list for new patients to come and get services, this new statute says that their non-competes are automatically void and unenforceable. Okay, so to cover that again, if you run a health, like a therapist or mental health counseling office, something along those lines, if your business has a 2-month or more wait list for new patients to be able to see a doctor or to receive services, then the non-compete agreements that those employees have signed, that your healthcare providers have signed, are automatically void and unenforceable, and which means that they are allowed to leave and go somewhere else and begin competing immediately because the business is so backed up that we have at least a 2-month or longer wait list for patients. So it's rather narrow. It only applies to small industry and healthcare providers. But if you are or in that industry, if you have friends who are in the industry, just know or ask them to reach out. We can talk with them about this new law. It just became effective at the end of May. And I really do think that these restrictions on non-competes are going that direction where, we used to be able to have a 5-year non-compete or even longer. But, about 8, 9 years ago, we had this new law that said, okay, we're only going to allow them to be up to 12 months. And now we've got this new law from just 2 months ago that says, you know what, they're going to be void for certain people in certain industries. And I think we're heading the direction of California and other states in localities where they say, you know what, non-competes, they just don't make sense. And as a business community, or as a state, we're going to change the rules and say that non-competes are not enforceable at all anymore. So we're not quite there yet in Utah, but I do think we're heading that way. My recollection is that for a number of years in a row, there has been a bill brought up in the state legislature to just do away with non-competes in the state. And it's made progress at various different stages, but it's never gotten far enough to be actually turned into a law. And so I think that effort, that momentum is going to continue. And I think sometime in the possibly not very distant future, we're going to see Utah probably follow the lead of some others like California and say that non-competes are just not going to be allowed anymore going forward. So thank you for joining us today. I hope this review, this Fired Up Friday review for the post-employment restrictions and how non-competes work, how non-solicitations are different and all that. Hope it was helpful for you. We'll announce the next one coming up probably another month or so, and look forward to suggestions from any of you. I know some of you have your own individual businesses you're running. It's good to see you on here. I love working with you guys. And so if you have legal issues you think would be helpful to talk about in a webinar or this kind of a setting, feel free to shoot me an email. Let me know what you'd like us to cover, and we'll get the next one up and running and get it announced, and look forward to seeing you all again next month. Thanks, everyone.